Thank you, Susan. Any questions for Susan regarding the administrative report? Okay, not having any, that will move us in to our public comment. And we do have some cards for public comment. The first one for non-agenda topics is Martina Ortega.
Hi, I'm Martina Ortega, and I'm sorry I haven't been here because I've been busy working. But I noticed that there's a change here. Could you explain that to me before I begin? The change of public comments? In the past, we were allowed to do public comments, and then we were allowed to do agenda items individually because we're not mind readers and we don't know what you guys are going to be reporting on.
I think we do have it in the agenda in terms of public comment and procedures. There was some changes at a previous SELPA meeting several months back approved by the council and legal counsel, and so the process is outlined here.
Okay, could I request public records who approved this, which of the superintendents approved this, and limited parent participation? Thank you. So I'm going to go ahead and begin, so I guess I have to say everything up front, and because I'm supposed to be a mind reader, I'm supposed to know what you guys are going to be reporting on, but that's okay. We'll go with that. I too participated in Legislative Day on May 1st with Ontario Montclair School District. I also went to advocate for special education students. I reminded our legislators that we are not opposed to more funding for special education, but we as taxpayers want it earmarked for direct services for our children, not for litigation like was in SELPA. If you look at the consent calendar, you know, of course we're making the attorneys rich, but our kids are still lacking in services. And we don't want it to go to administrators or staff raises, because as soon as, for some reason, you guys get more money, all of a sudden all you guys get raises. I too will be talking to Congressman Pete Aguilar tomorrow, as a matter of fact, because a mutual friend invited me to her home, and I will be discussing with them our side, the parents' perspective on the lack of support for special education children and the litigation and the open paycheck to attorneys to fight against services for our special needs kids. And then moving right along. To Coalition for Adequate Funding for Special Education Membership. D7, lobbying to secure adequate state and federal special education funding. I'm pretty sure we as parents can't join, even if for some reason we come up or we do a GoFundMe to pay the membership fee of $1,500, right? Because it's only open to probably the school districts or the county. E1, 2019-2020 annual budget and service plans. I hope that, Susan, you'll be able to catch up some of the superintendents that got here late on the parents' concerns during public hearing, because if not, what is the purpose of a public hearing if maybe not all the superintendents got to hear our concerns and lack of services for our children? Thank you.
Thank you. Our next non-agenda topic is Rita Luke.
Thank you. Good morning again, and thanks for the opportunity to speak. I want to echo Martina's comments, and you have heard me make these comments before about the procedure for public speaking. At least now we are able to hear the administrator's report before we give public comments. We are also talking to our legislators, and we're giving them our side of the story, not the SELPA side of the story. I want to bring up that for 3 years now, I have asked Susan to inform me of the private school meeting that takes place every year. And I am here filing a complaint against Susan for her failure and refusal to provide members of the private school community with the date and time of the meeting. For 3 years now, I've been asking her to let me know when the private school meeting is going to be at. And it's required under federal law that representatives of children with disabilities in private school be consulted with. And Susan has ignored my repeated request. So I urge you to take that into consideration when you appraise her performance. Generally speaking, since I'm under public comment, the training in this facility is restricted to staff. Most of the training that happens here is only available to staff, not parents. So this whole parent engagement, community engagement routine, it's a sham as far as the parent community is concerned, because we're not involved in the process. One of the few trainings that's made available is the clinical parent training, where parents are essentially told, it's your fault and go deal with it at home. But not like that, with a lot of platitudes, but you can read between the lines. Under item D, superintendent's business consent items, I want to call your attention to item D5. That consent agenda item has $10,000 for educational services, but $11,000 for attorney fees. That's emblematic of our structural problem here at the West End SELPA. The money is going to litigation, not education. And there was even a more egregious consent item at the last meeting where $5,700 was going to attorney fees, and there was absolutely no services whatsoever. You need to ask these questions on behalf of your districts. Otherwise, you're not doing your job on behalf of your districts. These are structural problems that need to be addressed. Somebody needs to be minding the store. You need to be providing oversight. You have Mr. Lord in the due process department that approves these items, and the...
It's not, I'm sorry, this is not working your time. The buzzer part of it, the timing was, you've gone over your time.
9 minutes I have multiple agenda items.
You didn't let me know how many items does she have.
Oh, so these are counted by ones too?
Well, we have to do it all, that's what Martina was asking, we have to do it all at the beginning now, unless you're going to let us testify item by item.
You're correct. You're correct.
Okay, that's what I thought, thank you. As I was saying, the structural problem here is that we need education, not litigation. We need more teachers and less lawyers. Mr. Lord in the due process department is basically running how he wants to run, bullying parents. I got several phone calls this week about his behavior, his unprofessional behavior, because nobody holds him accountable. He's making over $6-figure salary plus benefits at our public expense to be a public servant and not serving the public. He's instead bullying the public. And one of our community members put in a Public Records Act request for the policies and procedures that are cited here when you approve these items that say all these consent items are in compliance with the West End SELPA policies and procedures related to settlement agreements. There are none. Ask Mr. Lord, where are the policies and procedures related to settlement agreements, because he can't produce them to us. So either he's hiding them or there are none. Moving on to items 7 and 8, the Coalition for Adequate Funding in Special Education. Again, item number 1, as Martina pointed out, is the word lobbying. I don't think this agency should be in the lobbying business. I don't think SANDABS needs to be in the lobbying business on behalf of me and my constituents. They don't represent the interest that we have. These are shadow entities, and it is nothing more than a backdoor way not to tell the public the positions we're taking, but yet go to the legislature and represent that these are our positions. You need to be looking at what the adequate or the Coalition for Adequate Funding in Special Education is doing. More funding for the CELPAs doesn't necessarily mean more funding for your districts. We consistently have killed any effort to get more funding for the CELPAs for the reasons that Martina cited. This does not behoove your district. Have your district take a look at whether or not these policies will benefit your district. How does it benefit your district that you get a resource specialist fund for the CELPA to earmark the funding for CELPA staff? The rest of the items for legal services, Mr. Reed from FFF is in the audience. He's making money hand over fist. He's not an educator. You've allowed his law firm to basically run the CELPA. What do you think he's going to advise? He's going to advise litigation. He's not a teacher. He's not a reading specialist. If you ask him, Mr. Reed, would you like more money for the child to learn to read, or would you like to take this to court? He's going to tell you 9 times out of 10, he's going to take it to court. I don't blame him. He's doing his work for his corporation. Now we expect you to do your work for our public corporation. Your public employees, these are public entities, and how you're running it is you're letting these lawyers run the show. And that's where it's falling apart. You're not giving the supports to teachers. We heard at the county board meeting that 50% of our paraprofessionals in the county are at risk of being laid off. But we have these huge communication budgets and these huge lobbying budgets. And we have Susan misrepresenting to the legislature that West End CELPA is supporting bills that the community does not support and that do not come before your body for approval. Because I can agree to disagree if she were to follow the process, but SANDAPS is not West End CELPA. Again, the amount of litigation that's being used is shown on item E3 for the Joint Risk Contribution Fund, previously called the XPOT. Look at the numbers. 14-15, it was $30.36, and 19-20 is $43.04. And there's a lot of back and forth about all of a sudden the CELPA found recently $1.236 million. And I just don't see how you find that kind of money, but when you have a budget of $211 million and $7 million is going to administration, 7.6, then $1 million is not that big of a deal to you. In the meantime, you're bullying the special ed parent community. I know many parents that have to go to due process to get basic services. And like I mentioned, $10,000 in education, $11,000 in attorney fees. And by the way, that doesn't include the fees that you're paying to Mr. Reed, who's in the audience. Look at all the legal services, 9 through 12. They're all legal services, multiple law firms. I don't see any behavior specialists on this. I don't see any counselors. I don't see any reading specialists. Oh, that's why the box for reading services is not checked under your budget service plan. Thank you.
Thank you for those comments. We do have 2 additional cards. One is a blue card that says encroachment. There's no name on it.
Oh, sorry about that. That's me.
Okay, and there's another one that it's a white card that says D9 with no name. Is that also you?
Yeah, I got a copy of that.
Okay, so if you'd like to come forward and speak to those 2 items?
Sure. Well, I heard Ms. Bobbitt talk about it, mention encroachment, didn't talk about it, that's unfair. But she mentioned it, and you guys talk about encroachment a lot where SPED is concerned. And the idea seems to be that SPED expenses encroach on the general ed budget. That's not really the right way to look at it, however. Because really, SPED is about the most effective use of your money that you got. SPED is what properly spent, is what will take a kid who might be institutionalized at hundreds of thousands of dollars a year. I heard in the county board meeting that locking up a kid in juvie is $360,000 a year. I'm amazed to hear that, because when adult gets to the state, I understand, are only about $75,000 a year, which is also a lot of money. That's what happens when SPED isn't done properly, is kids with learning disabilities, unrecognized because the district spent their whole career playing keep away, they end up locked up, and it turns out that, and that encroaches on education. The money which is just pissed away on the correctional system and on the juvenile system and on institutionalizing people, huge amounts of money, that encroaches on education. And that happens because you guys play keep away instead of addressing the needs of kids with learning disabilities who, if you spent a few $1,000s there, a few $1,000s there sensibly, would do a great deal better. Now, you may take a severely disabled kid and you're not going to turn him into a special education lawyer, but you will turn him into somebody who's more or less able to function, actually pay some taxes maybe, instead of being institutionalized. That saves an awful lot of money, and that money is going to come back to you guys, because it's going to be easier for you guys to get education money when you guys are spending money to keep people out of the correctional system and whatnot. So that's the encroachments that you ought to be thinking about, the big-time encroachment on education that comes about because of the harm that you do to these kids by hiding from their needs, and then you end up having to pay to imprison them or institutionalize them. That's encroachment. And that's something that you can do something about by working less hard. Working less hard to play keep away. And actually figuring out what would be an economical and simple way to actually give the kids some help. Even if you could find an excuse not to, just go ahead and do it. Because if that kid doesn't end up in the criminal justice system, you're not going to have as much trouble funding things, because it'll be easier to get people to give money to education. Two reasons. One, there'll be more money there, and the other is you'll be more effective, and the legislators will be more happy to give you money for being more effective. That's two reasons. Think about that. That's encroachment. Now, the other one is a different item, so I should have another 3 minutes.
No, it's been 3 items. We only had 2 items. It's 3 or more items, I believe.
What? I thought you get 3 minutes an item.
He had 2 cards, that would be 6 minutes total. Did you time it for 6 or just 3?
I just typed it.
So he would have another 3 minutes, you're correct.
Thank you. Thanks for review. That's good. I have a little to say here. This is just concerning Fagan, Friedman, and Full Frost and funding them. Now, Upland has developed an ADR process that should work. They hired a guy in LA by the name of Mark Perchin. I met with him in Farenga once last week on a case. And we arrived sensibly and quickly at a deal. And then it was given to their lawyers to look at. Their lawyers didn't look at it. They rewrote the contract so that it had about as much to do with what we'd agreed on in the meeting as 2% juice drinks have to do with actual juice. There was hardly anything left. So basically, Mr. Perchin's time was wasted because we came up with a deal and then the lawyers rewrote it very dishonestly in order to cheat the parent. Well, it's my job to read settlement agreements, so of course I read the settlement agreement and you know, found these different things, and maybe we'll get it straightened out or maybe we won't. Now, I'm not faulting Mr. Frank on this because Mr. Frank is not that good at reading settlement agreements. I have evidence in my dealings with him that he's an honest fellow and means well, and he wasn't trying to cheat us. Fagan, Friedman, and Full Frost was trying to cheat us. They were the ones who rewrote the agreement with the hope of swindling the parent because I wouldn't notice what they did to the parent. Really pretty egregious stuff. And what is the point in hiring a fundamentally dishonest firm to get you into trouble and into needless fighting? Because Ferenga and I and the parent don't want to get into a fight. They gave it to Fagan, Friedman, and Full Frost, who then went and set it up for a fight. So I'm sure Upland's not the only ones who experienced this. I've seen this, in fact, with other agreements they've done. This